Hello, this is Matt on the Moon Lambo channel. Just last night, I published a Moon Lambo hot jam all up in the YouTubes, which I discussed a number of things, including the fact that the entire XRP community was expecting today to have in our grubby little mitts a bunch of unsealed memos having to do with the SEC versus Ripple case. This is some of the things that are the heart of the matter, including what Ripple thought and was informed about whether or not XRP was a security dating back to, I think, as far as 2012, which, by the way, is the year that Ripple, the company, was actually formed. What did we get today? Not that. Now, it's still coming, and in fact, my understanding is, in all likelihood, we're going to get it tomorrow, but there was a little bit of a change, which I'll explain in just a moment, but I will tell you this here right at the outset of the video. Ripple is now insisting to the judge, effectively, that they do not want any censorship of these memos that are to be released. And we know the memos are coming out regardless. Just a question of whether or not the judge would allow any redactions if either party, Ripple or the SEC, want any redactions in any documents for any specific reasons. But Ripple's insisting, no, we do not want any censorship. We want these memos to be released in all their glory. No redactions, because Ripple believes very strongly that it paints the nature of their side, their perspective, very positively. Also, we found out which law firm it is, that advised Ripple on whether or not XRP was a security, and you are going to be very surprised, probably. You've heard of the firm. If you've been following this case, you've heard of the firm, which kind of gives it away a little bit, but I'm going to tell you who it is and get into the specifics, but it's just amazing to see the implications of what it means, because it has to do with the whole Ethereum free pass speech as well. Look, plenty to talk about here, but before we're going further, I do want to be clear at the outset, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto topics, but just as a hobby and just for fun. Now, I did print up this document. You can hear that right now in the microphone? That's some dead trees up in this barrage. And so I highlighted the parts of this most recent legal filing from Ripple's legal team. I'm going to share with you the parts that I found most relevant. It's just a handful of portions. And then we're going to get to the only attached exhibit to this legal document, which you will find fascinating. And I don't know if I'm mistaken here. I'll mention this before I forget. Exhibit E, which, again, I'll cover this towards the tail end of the video. That's where some of the media stuff is here, in terms of, what the law firm had to say and who it is. But I could swear that I have actually seen this email thread before, but it just happened to have had heavier redactions. So I think this part of this was actually out in the public, just heavily redacted, and now there's only one tiny redaction, which is inconsequential, and you'll see why when we get there. Very interesting stuff here. And so just a bit earlier today, before we got the most recent legal filing today from Ripple's legal team, attorney James Filan, who is a member of the XRP community, tweeted out the following. In part, he wrote, "The unsealing of the legal memos also should happen today. That depends on whether Ripple files newly redacted memos or just allows the court to unseal the previously filed and redacted memos." And so there you go. That's a tweet from him. So the reason that we didn't get them today is because Ripple actually did have an adjustment, but it's a good adjustment. Not that they wanted more redactions or anything to that effect. They're just like, nope, take out the redactions. We want this to be viewable by the general public in all of its glory. Now, as far as the redactions go, it's worth noting this in case you missed my video where I was talking about this topic last night. It's worth knowing also that regardless of if there's any redactions for the documents that are unsealed and that we end up seeing, that has no consequence. That is of no consequence to the case whatsoever, because Ripple and the SEC and the court, they all see the unredacted version. So when we're talking about these documents being unsealed, it's unsealed for the public, meaning we get to see it. But the impact of this, it's already out there. These memos, they're already out in the wild. They're part of the discovery process. So yes, that part is already set in stone. It's just a question of how much we'd get to see. And now it's looking like a virtual certainty that we're going to get to see about 100% of what is covered in these memos, which from my perspective is fantastic news. And apparently Ripple now is very happy to see that as well. And Eleanor Terrett, who is a Fox Business Network journalist, tweeted out the following. And this was just this morning. New, Ripple's General Counsel, Stuart Alderati, statement to Fox Business. And this is a quote now to Fox Business. Once released, these documents will show that in 2012, Ripple received a legal analysis that XRP was not an investment contract. The fact that it took the SEC 8 years to suggest they disagreed with that analysis while XRP traded in a massive global market is baffling. We look forward to the public having access to these documents as we continue to vigorously defend this case. Yeah, well, I'm looking forward to that part tomorrow, but I still at least do have something to share with you today in terms of legal documents. And so shout out to Attorney Filan for sharing this document, which I will be hopping into in just a moment. But first I want to share a couple comments from Attorney Jeremy Hogan, which are brief on this topic, but I want to share with you what he had to say, just initial impressions. So upon Jeremy Hogan initially doing his read-through of the document, which again I'm about to cover in just a moment, he tweeted out, "If it's coming out, let it all come out. Hashtag the full Monty." And then he wrote, "What happens next? The judge will do a quick order to the clerk to unseal the exhibits. Because it's after 7 p.m. court time, this will probably happen tomorrow. I don't think we'll see anything tonight." And so there you go. That's why I started out towards the beginning part of the video saying I don't think we're going to see any additional memos this evening, but we still do have something. Don't worry. But plenty to talk about tomorrow on top of what we're already discussing today. It's always a lot of information, is it not? And then there was this. So let's go ahead and jump into this document now. And so, again, I don't want to read the whole thing. It wasn't that long, but still, I just highlighted a few parts. And then I'm going to run through Exhibit E, which is an actual very short email thread between Chris Larson, co-founder of Ripple, and Ryan Fugger also. And so let's go ahead and jump in here. And this is to Judge Torres, written by Ripple's attorneys. And there are 4 points here in the top portion of this legal file. There you go. I highlighted some of what I'm going to cover here. Number 1. Ripple and Mr. Larson do not oppose unsealing the legal memos in their entirety. And then number 2, Ripple and Mr. Larson are submitting with this letter a version of Exhibit E with one limited redaction for the public docket, a redaction to which the SEC does not object and respectfully requests that the unredacted Exhibit E remain under seal. And so there you go. First, when I read that, I was like, okay, what does Ripple want to hide there? It's actually nothing. I'll tell you right now what it is. It's the name of one of their equity investors. So an investor in Ripple, the actual company, dating back to whenever they would have invested, whether it's 2012, 2013, 2014, because the emails were from 2014, I do believe, anyway. And so that's all that is. So you can read through the rest of it. It doesn't mess with the flow or the context of anything. You can still tell exactly what's being discussed. So on that front, I'm just like, okay, yeah, that sounds perfectly reasonable. And that's the only thing, mind you, that they want redacted. And even the SEC doesn't have a problem with it. If that helps you to understand just the degree to which this really doesn't matter and is truly inconsequential. Even the SEC is like, yeah, that's fine. Keep it redacted. Whatever. No big deal. So that was pleasant to see because everything is a point of contention between these parties. And it's mostly as far as my humble opinion, it's my perspective that the SEC is just being a big old bully for a lot of this. And I don't believe that they believe what they're arguing, but you know my stance on all this stuff. Point number 3. Ripple does not oppose the unsealing in full of the SEC memo and Ripple's opposition. And number 4, Mr. Larson does not oppose the unsealing in full of the Larson memo, the SEC opposition, and the Larson reply. So it looks like there are going to be several memos that are going to be released that we've not yet seen, or if we've seen any parts of it, there's just crazy redactions and we couldn't make heads or tails of it anyway. And then let me go to the next page, page 2. There's not much more to cover on this part. Then I want to get into that email because you guys are going to have some fun with that, let me assure you. Or almost at the next page. Okay, Ripple and Mr. Larson are not proposing redactions to the legal memos. Mr. Larson believes that if any part of the legal memos is unsealed, then both documents should be unsealed in their entirety so that the public can review the SEC's characterizations of those documents in their full context. And so I thought, wow, this speaks to the degree to which Ripple very strongly feels that this is evidence that favors them and not the SEC. That's what I was initially thinking upon reading through this, and that may well be the case, but there's a little bit more to it. As it turns out, the SEC also wants everything completely unredacted. The SEC doesn't want censorship. What? which is kind of funny to see, especially considering the degree to which, well, I guess most of it was a discovery battle, which is a little bit different than this, obviously, but the degree to which they don't want to submit all sorts of what we would assume to be highly relevant documents having to do with Bitcoin and Ether and XRP. They don't want that to be part of the discovery process. They've been fighting against that with great vigor, let's say, and doing everything they can for months on end to keep those documents out of the hands of Ripple. And so anyway, then it also reads as follows. We note that the SEC previously filed proposed redacted versions of these documents. However, after conferring with the SEC, we understand that the SEC agrees to the unsealing of the legal memos in their entirety and is not requesting redactions. Folks, why are they doing that? Is anybody else curious about that? Why are they suddenly okay with the public seeing this information? Have they're just thrown in the towel because they already know that the public hates them? Because I'll tell you what, the investors that they're allegedly protecting out there, you and I, we're not so thrilled with them, let's say. I don't know what it is. Now, again, it doesn't impact the actual nature of the case. The judge is going to get to see this all regardless. Already has seen it all. It's just a question of whether or not we get to. So why doesn't the SEC care if the public gets to see this? Do they really believe that the evidence is that strongly in their favor? I'm not convinced of that because what I found is that, like I said, so many arguments that they make, I don't think they believe. I really don't think that they believe like most of the stuff that they're arguing. And it's a bunch of nonsense. It's not logical. There's a lot of hypocrisy, all sorts of stuff along those lines. Now take a look at this. So here's the email in question. And again, I could be mistaken, but as upon reading this, I was like, I could swear I've already seen this before, but just like a more redacted version. And so there is an email from Ryan Fugger dating back to May 26, 2014, and he wrote the following. It's very short. He wrote to Chris Larson, co-founder of Ripple, the following. So, just to get it straight, what was the reason the founders kept 20% instead of giving it all to RL? And so what he's asking there is, what's the reason that the founders kept 20% of XRP and the rest of it went to Ripple Labs, which is RL, in this short email here? And Chris Larson responded with the following. You can see there's just one little redaction here where I'm circling, where there's that equity investor whose name shall not be revealed unless the court says, no, we're going to reveal that, which doesn't seem very likely. That doesn't sound right. Even the SEC doesn't think that sounds right, so that's fine. Doesn't matter, but that's what it is. And so Chris Larson's email reads as follows. Founders were issuers rather than Ripple Labs, so Ripple Labs could be a user, not an issuer. Founders assumed risk of issuers, which persists today. Founders assumed risk of. He meant being. Yeah, it is a typo. Okay. He wrote bring. He meant being. So I'll read it the way that he intended. Founders assumed risk of being issuers, which persists today. This protected Ripple Labs and was a key part in our first convertible note with investors like blank. That's the redacted portion. 20% was compensation for founders personally assuming this risk. And so, I've talked about this concept before, and I knew that this was the reason that the founders got the percentage that they got was to assume personal risk. Now, whether or not you think that percentage is fair or unfair, that's a discussion for a different day. It's worth noting that upon them receiving 20% of the total quantity of XRP. It was 20% of an asset that was worth $0.00. There was no guarantee it would be worth anything in the future, and any parties that chose to purchase any sort of XRP given in an open market value because it ended up getting traded on exchanges, like all of this was public knowledge. There was no sort of secret that the founders had X amount of XRP and Ripple Labs had what they had. There was never any sort of secret about that. And so if people were okay with that, then they could choose to invest. And if they weren't okay with that, then they could choose not to invest. It's up to you to do your own research if you're going to purchase anything in life. I don't care if it's cheeseburger. You do your own research, man. What kind of meat is that? Is that real meat? Is that fake meat? What is that damn stuff? And so, to me, it's all about personal responsibility. That's just my personal perspective on stuff like this, just in general. I want more freedoms and less of a nanny state. I don't need the government telling me what I can and can't do. And if my decisions bite me on the rear side, I say, so be it. I don't need them to protect me from myself, okay? And if people make bad decisions, you know what? If it hurts them, that's just life. I'm not saying there shouldn't be any protections against fraud or stuff like that, but I do think that there's too much of a nanny state. I'm just saying. Anyway, then the email reads as follows. It proceeds. And this is where we get to who the law firm in question was. Check this out. Also, analysis from Perkins Coie was that investors and employees could not receive XRP, could risk SEC designation of a security. Only founders could. Jed, Arthur, and me. Whoa. Okay, lot to unpack there. So take a look at this. You guys, that name Perkins Coie sounds familiar, right? Well, here's a little reminder just in case. Here's a headline. I just pulled up a random one from this past September titled, Former SEC Chairman Clayton directed Perkins Coie to draft memo giving Ethereum and Bitcoin unique advantage in crypto space. Then his SEC sued their top competitor on day Chairman Clayton left SEC. So yes, this is the firm that Clayton directed to draft a memo which ultimately led to the Ethereum free pass speech that Bill Hinman gave in June of 2018. Perkins Coie. And Perkins Coie is the ones that is the firm, again, that's being referenced here in Exhibit E here, in which Chris Larson is writing to Ryan Fugger. Crazy stuff, right? Freaking crazy stuff here. And so, again, let me read that one more time. Analysis from Perkins Coie was that investors and employees could not receive XRP, could risk SEC designation of a security. Think about that. So Perkins Coie told them, if you give XRP to investors and employees, if I'm reading that right, was that investors and employees could not receive XRP. So if they were to give employees and investors XRP, that could risk the SEC designating it a security. That's analysis from Perkins Coie. And so what this email is saying is that they didn't do that. So if it's true that they didn't do that, then indeed, just use your own logical brain there. You can figure out that this favors Ripple's argument. What's being stated specifically here, assuming that's all true, this is good for Ripple. Now, I do have a question here. We know that Brad Garlinghouse ended up owning a ton of XRP, and he didn't come on board with Ripple until it was like 2015, maybe 2016. And he wasn't initially CEO. He had a different position. I can't remember what it was off the top of his head. But we know that he sold a bunch of XRP. So I'm just curious, where did Brad get his XRP? Because he wasn't there as a founder, obviously. And did something change? Did Ripple actually give it to Brad at some point? Was it part of his compensation package, which I've been curious about for some time? Not that it's actually in my business or yours, but I was just kind of curious. Or did Brad Garlinghouse do what David Schwartz did? Because David Schwartz wasn't gifted any XRP. In fact, he didn't want to take on that risk exposure. David Schwartz, all the XRP he had, he purchased on the open market. So did Brad Garlinghouse also purchase his XRP on the open market? I don't think we have the answer to that. I've never seen the answer to that, so I'm just curious here. Isn't that something, though? And then also Chris Larson wrote further, post-March 2013 FinCEN guidance, the Ripple Labs designation as a user rather than an issuer is and continues to be key, reducing risk to Ripple Labs holders like Jesse, increasing risk to founders/issuers. Further, the ledger was reset hundreds of times leading up to the public launch in December 2012. Nonetheless, the ledger simply reflects property ownership of XRP, which was founders 20%, Ripple Labs 80%. Hope that helps, Chris. Yeah, and that's a fun little fact for those of you that may not have heard it. The XRP ledger, when it was going through the final phases of development in particular, it was reset a number of times with tests, and then eventually the final version... David Schwartz has publicly talked about that. They didn't realize that was going to be the final version. And there was that error around block 32,000 and something, somewhere around there, in which there actually was a bug. And so there was this bug. It was discovered before the XRP ledger was released. And so what they did was they actually released the final product, but not knowing that that was going to actually be the final version. And as a result of that one time, they happened to have not reset it. So it didn't go back to block 0. You know, or well, technically first block would have been 1, but you know what I mean, go back to 0. They actually didn't. And as a result of it, the Bitcoin maxis like to pretend like there's some sort of bastardized blockchain that doesn't work because there was a bug and there's like some missing ledger headers. And the truth of the matter is, whether or not you reset it and you consider block 32,000 something the Genesis block or block 1 the Genesis block, what I'm saying is, even if they had reset it and then it would have been block 1, it still would have had that history. It just would have been reset, and it wouldn't freaking matter. It was not open to the public. There was no consequence to this. Nobody lost anything. It doesn't matter. But it's just a fun little piece of the XRP ledger history, and so it is what it is. So I'm very curious to see what's in the rest of these these memos, which again we're probably going to see tomorrow. From what I've read from Attorney Filan and Attorney Hogan, seems like more likely than that we're actually going to get this tomorrow. But this is where we're at with everything right now. And how about Perkins Coie, man? Ended up providing legal advice for Ripple. This is the firm we were always wondering who it was. Now we know. And then they went on to draft up some suggestions that ultimately became the Bill Hinman Ethereum free pass speech. What in the ever-loving hell? It's a weird world that we live in, folks. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.